So let's take a look at what's going on here. Ernesto van der Sar from Torrent Freak writes, as part of an ongoing piracy lawsuit, Nintendo has filed a motion to subpoena Reddit, Discord, and other platforms for information related to the alleged operator of several pirate shops. The game giant seeks information on the defendant who previously served as a moderator of the SwitchPirates subreddit and suggests that Reddit may be able to identify additional pirates. A purpose of this is to identify further pirates and to file an amended complaint against them. So let's take a look at the actual filing here. Okay, so we already have a case here. This is document 19. If we're starting with document 19, maybe we should instead start with the actual docket and see where we are. So this is Nintendo of America versus Williams. Here's a complaint filed on June 28th. Then a summons issued on July 2nd. An affidavit of the service of the summons on August 14th. A bunch of attorney admissions, and then a request for entry of default, which means the defendant, Williams, did not respond. I don't see anything on the docket here that indicates a response. So the court enters default November 8th, and so default is just the first step. Default just means you didn't respond to the lawsuit, and you've lost the lawsuit, but we're not done yet. We don't know what you've lost. We just know that the judge has said you've entered this special state of having lost the lawsuit for not responding. So in order to determine what you've lost, you have to go further to a default judgment. That is what Nintendo is preparing here, is for the default judgment motion, which will then ask for an amount of money based on something, like based on what they can find from their further discovery that they are then asking for leave to take further discovery. So that's where we are in this document, is they are now asking to take leave, or asking for the court's permission to take early discovery. Discovery needs to be conducted during a particular phase of the lawsuit. We are in the default judgment phase. The complaint has been served, but a answer has not been filed. There's been no response. So now we're in this default phase. We still haven't completed the Rule 26 procedure, which really just means a status conference with the judge and some initial disclosures between the parties and things. Because we haven't completed that, we don't have the procedure completed for the subpoena. So they have to ask for the subpoena instead of following legal procedure for the subpoena. So, I mean, this is following legal procedure. The legal procedure is that you're out of order and need to ask for express permission. Plaintiff, Nintendo of America, respectfully requests leave to conduct limited third-party discovery, which means discovery conducted to like Reddit and GitHub and stuff, not to the parties of the lawsuit. Discovery to 1, aid in preparation of its anticipated motion for default judgment against James Williams, Archbox, the defendant, and 2, to ensure that all appropriate defendants have been named. So they want to name additional defendants. Nintendo filed this lawsuit against defendant June 28th for copyright infringement and violation of the DMCA's anti-circumvention provisions. Nintendo began diligent attempts to effect service, finally served defendant on August 13th. That looks like this. So this says that James Williams, aka Archbox, was served by the process server leaving the summons at the individual's residence with a Jane Doe, a person of suitable age, at that address in Arizona on August 13th at 5:24. And they mailed a copy to the last known address and wrote this additional information. I delivered the documents to an individual who refused to give their name, who identified themselves as a co-resident, so that meets the legal procedure. The individual accepted service with direct delivery. The individual appeared to be a brown-haired black female, 25 to 35, 5'6" to 5'8", 140 to 160 pounds, spoke to a very helpful female resident who confirmed identity and residency of defendant. She stated she was planning to move out soon, but confirmed living with him. Subject and female ordered DoorDash, and I followed the delivery guy up to the door and spoke with the female resident. There you go. That's how you do it. You want to get process served on somebody who is rejecting your attempts at process service? Follow the DoorDash guy to the residence. There you go. I followed DoorDash up to the door, spoke with the female resident. She indicated she would accept the documents. She was helpful and cooperative. So almost sounds a little bit like a spiteful ex, maybe. I don't know what's going on in this person's personal life. I don't claim to know. I don't want to know. But there's some inside information for you from that. So they served him. He failed to answer or respond to the complaint in any manner since then. It is now December 1st, as of this recording, depriving Nintendo of the opportunity to take discovery from the defendant and requiring Nintendo to prepare a motion for a default judgment, as I said. Nintendo seeks leave to serve narrowly targeted subpoenas on a limited number of third-party internet service providers who are likely to have information relevant to Nintendo's anticipated motion for default judgment and amended complaint naming additional defendants. So Nintendo develops the Switch console, has many US copyrights, sells millions of copies of video games, etc. Defendant, who I'm more interested in, creates, operates, oversees, promotes, and assists others in doing the same. A network of unauthorized online shops nicknamed the Free Shops, which offer to the public for download extensive libraries of pirated video games for the Nintendo Switch console. Defendant's unauthorized shops, which go by the names Jack in the Shop, Turtle in the Shop, Libera Shop, the pirate shops is what they're going to call them, have been among the most insidious drivers of video game piracy over the past few years. Through his role in the pirate shops, including his active promotion and facilitation of their use, defendant has provided to members of the public a nearly limitless supply of video games, in particular Nintendo Switch games, free for the taking. To sustain the pirate shops, defendant has engaged in crowdsourcing schemes, such as a scheme by which members of the public are solicited to donate prepaid Nintendo eShop gift cards, which are used to purchase games, etc. I don't know why I'm explaining to my audience what an eShop gift card is. Or copies of pirated Nintendo game files. And I'm sure you know this, they take the gift cards and sell the gift cards, at a discount to get the cash. It's a kind of money laundering. Defendant's activities also include knowingly trafficking malicious and unlawful software products to circumvent Nintendo's technological protection measures on the Nintendo Switch games and on the console. So this was, I don't know if you remember, there was a guy named Bowser who got arrested for criminal copyright infringement. Damn, I forget the name of the rest of the organization. Team Executor was the name, but yeah, there is a criminal component to copyright infringement, and we're getting dangerously close to it here with the mass selling of circumvention technology specifically for piracy. You're allowed to sell circumvention technology in the greater sense, but you invite a ton of legal scrutiny, so you'd really need to work with an attorney who knows what the heck they're doing. You might want to have insurance for this as well. You might want to have an LLC or a proper entity to protect you from the inevitable lawsuit and maybe charges. Because if you sell a circumvention device that doesn't meet the legal requirements for such a device, then it's piracy. You're promoting piracy, you're violating several criminal laws, and you're going to get yourself arrested eventually. Fortunately, the type of piracy we normally see, just like basic online downloading, which can share, like BitTorrent shares as it downloads, they don't seem to get the criminal copyright infringement charges as opposed to lawsuits. So this is Nintendo doing a lawsuit, a civil lawsuit instead. Defendant also hosts websites and online communities dedicated to circumvention software and to providing assistance. So he has a support system as well. Defendant has been an active and highly prominent member of the Reddit community r/SwitchPirates, self-described as a community by pirates for pirates. Via the SwitchPirates Reddit board, defendant has touted and advertised his pirate shops and offered technical advice and encouragement on how to obtain and play pirated Nintendo Switch games and use the circumvention software. Defendant's scheme has caused Nintendo damage. Nintendo has reason to believe that some certain unnamed individuals have been working in concert. See the declaration of Mark Mayer. Let's take a look at Mark Mayer's declaration. I am an attorney licensed to practice in California and admitted pro hoc vice. I am a partner of Mitchell Silberberg and Knoop, attorneys of record for Nintendo. Defendant and other individuals created, operated the pirate shops. Other unnamed individuals knowingly trafficked in malicious or unlawful software products designed to circumvent Nintendo's technological protection measures that protect access to the games, the software. Prior to filing this suit, we conducted an investigation. Over the course of the investigation, we learned various details about the pirate shops and defendant's involvement. We learned defendant was active in numerous Discord servers related to the pirate shops. Defendant was the primary moderator of SwitchPirates and apparently the owner of a GitHub account directly tied to these activities. Defendant operated as Archbox, the username Archbox, or a close variant. Through diligent research and investigation, we were able to connect these activities to Mr. Williams in Phoenix, Arizona. In the course of our investigation, we became aware of multiple other online actors who had roles in the shops. We were unable to determine the identities or locations of those actors with sufficient degrees of certainty to name them in an initial complaint. Nintendo of America thus did not include these individuals in this lawsuit, with the exception of the ordinary discovery of Mr. Williams might reveal the identity and locations of other actors. Defendant Williams apparently undertook deliberate efforts to destroy publicly available information relating to the pirate shops. The shops were open and operating at the time of the complaint, and then they stopped operating shortly after the lawsuit was filed. We have reason to believe defendant has deleted the materials related to these pirate shops. Then Nintendo began diligent efforts to serve Mr. Williams, and you heard about that before. So the discovery that he asks for, just while we're still in the declaration here, Nintendo is not able to depose Mr. Williams and therefore obtain more discoverable information from him. So they are requesting the third-party discovery to obtain the identity of the unnamed individuals, and they will also likely have other information as well. They are seeking subpoenas to Namecheap, Two Cows, GoDaddy, Cloudflare, GitHub, Discord, Google, and Reddit. Limited subpoenas to confirm the identity of the account holders and payments made, and aggregate traffic across the pirate shop's websites. They go into what all the services are. We know what all these services are. If you don't, just ask one of us in the comments. I'm sure someone will very politely tell you. Back to the motion for the subpoena, the motion for early discovery. That investigation identified defendant as the central operator and promoter of the pirate shops. There are other anonymous actors, like we just said. We just went through the list here. We're going to do it again. This time they have details. So Namecheap and Two Cows were the domain name registrars, and defendant used the privacy functions or features of those sites to conceal the ownership of those domain names, GoDaddy included. Cloudflare was used to hide the IP addresses of the actual web host servers. GitHub hosts software. Discord hosts communities, and one of them was a pirate shop community. And Google has Gmail and Google Drive, so those things can be subpoenaed as well. And Reddit, of course, is a publicly available forum. So that means that Reddit posts are also available to be subpoenaed. I mean, even if they're not publicly available, if there's records, it can be subpoenaed. And so then Nintendo argues. Here's the argument for this subpoena. District courts have broad discretion in scheduling discovery, including broad discretion to order expedited discovery prior to a Rule 26 conference. If you don't know, my day job, my not YouTube job, is to represent people who get these pre-Rule 26 subpoenas in response to a company seeing online piracy suing by IP address as opposed to suing a named defendant directly. So I see this every day. I see these pre-Rule 26 subpoenas. I know how to handle them. This is kind of like my job I'm looking at here, but now Nintendo's doing it instead of an adult entertainment company called Strike 3 Holdings. So it's a little weird to be looking at this with that lens. That's from the Hallett v. Morgan case. Here we're in the West Coast, so it's the Ninth Circuit, so they're citing to Ninth Circuit appeals court cases. Federal Rule of Civil Procedure 26D1 authorizes a court to permit discovery before the Rule 26 conference upon a showing of good cause. This is just a procedural thing. This doesn't mean that the law or the philosophy of law works like this for everybody. Just under federal law, federal procedure, the court has this conference with the parties, and then discovery commences. So you can't send subpoenas legally before that procedure. This is the threshold where you're not allowed to submit discovery requests anymore, or where you're not allowed to submit discovery requests until this threshold. So the court now has to do this good cause inquiry. And just to make it clear, they have all these interchangeable words for this. It's pre-complaint discovery, it's Rule 26 discovery, it's expedited discovery. So please don't get too caught up in the language. I'll try to interpret it for you where I see it. Good cause for expedited discovery exists where the need for the expedited discovery in consideration of the administration of justice outweighs the prejudice to the responding party. So we're asking for early discovery. Does that create a burden on the responding party? And is that burden outweighed by the need for the early discovery? Courts routinely allow early discovery where it will substantially contribute to moving the case forward and is narrowly tailored for that purpose. Relevant factors in assessing good cause are the requesting party's diligence, its intent in seeking the information, and whether the opposing party will be prejudiced if the court grants the motion. And here, of course, they're saying good cause exists. They have to inform the scope of the default judgment, learn more about the case so that they can ask for a default judgment, and then they need to identify the additional defendants. So how will the discovery be narrowly tailored and move the case forward? Nintendo says, the narrowness of the requested discovery militates in favor of granting the proposed discovery. Nintendo's intended requests are narrowly tailored, no broader than necessary. The necessary contours of a default judgment and permanent injunction, and any other individuals to be properly named in this action. Because the discovery sought will seek identifying information that service providers are required to be collected or use in their services, it is likely to reveal the identities of individuals or others primarily responsible for the pirate shops and defendants' activities. This requested discovery will contribute to moving the case forward. Defendant and those who have worked in concert with him operated in secret in connection with multiple groups. The defendant has defaulted. Nintendo is unable to take further discovery. Therefore, Nintendo lacks a complete picture of the full range of defendants' infringing activities and related offenses, relevant to damages and the proper scope of an injunction, as well as knowledge of associated individuals who may be appropriate to name in an amended complaint. See Crayho GmbH versus Overlord Limited, finding good cause, I'm guessing for such a subpoena, where defendant has failed to respond to the complaint, plaintiff is prevented from participating in a Rule 26F conference or other discovery. Finally, there can be no doubt that Nintendo's claims have merit as detailed in the complaint. Defendant has not bothered to contest. Defendant's scheme involves the large-scale piracy of hundreds, if not thousands, of copyrighted Nintendo game files. Nintendo has been diligent in seeking the information. To prepare the complaint, Nintendo expended significant time and resources to investigate defendant's identity. They have exhausted their ability to discover further information, and defendant's failure to appear impedes further discovery. Therefore, good cause exists. Nintendo's intent is proper to ensure appropriate relief in the default judgment and to allow the naming of additional parties. These are valid purposes for seeking expedited discovery. Courts have granted similar discovery requests, Creho, Adobe, and others, allowing third-party discovery in an effort to discover the full extent of the counterfeit dealings and support the motion for default judgment. Microsoft, allowing third-party discovery for a default judgment. Reebok International, limiting discovery for the purpose of determining the scope of defendants' infringing activity and proof of sales and operation. Courts also routinely allow early discovery to identify co-conspirators, where the identity of alleged defendants is not known prior to the filing of the complaint. This is where my cases are. The plaintiff should be given an opportunity through discovery to identify the unknown defendants, unless it is clear that discovery would not uncover the identities. Here the complaint named a single known defendant while noting that others participated in his scheme. Allowing discovery is especially appropriate where individuals use pseudonyms or anonymously commit tortious acts over the internet. UMG Recordings versus Doe. Courts routinely find good cause exists to issue a subpoena to discover Doe's identity prior to a Rule 26 conference. Yes, and this has happened 20+ thousand times since then in the Malibu Media and Strike 3 Holdings cases that I represent. So yes, this, fortunately or unfortunately, whether you like it or not, this is what the law has said. Where suit still in the early stages, it was appropriate to name a new defendant in an amended complaint, even if they had waited till they had sufficient evidence. Defendants will not be prejudiced. The discovery sought would have been propounded anyway had defendant not defaulted. The proposed subpoenas will place no burden on defendant at all, who by defaulting is avoiding compliance with discovery obligations themselves. Any prejudice to defendant is minimal. For the reasons stated above, Nintendo respectfully requests the court enter the proposed order. Here's the proposed order. The matter is before the court on Nintendo's ex parte motion for leave to take early discovery, limited early discovery, the court having considered plaintiff's motion and supporting motion, being fully apprised, plaintiff's motion is granted, etc. Now keep in mind, this is a proposed order, but you notice how it says like proposed here in brackets. This is actually supposed to be the unsigned order that you give to the judge. The judge doesn't prepare it. The clerk doesn't prepare it. The court staff, the employees of the government don't prepare this. The plaintiff's lawyer prepares what they want in the form of the court order, and then the court reads it. And if the court agrees, they sign it. And there is almost nothing that can make you more proud as an attorney as when you write a court order and the judge signs it without questioning or correcting it. It's a really good feeling to know that you did the thing the judge agreed with on the first try. So in this case, they're asking for the motion to be granted, of course, and the grant means they are granted leave to seek limited discovery from the following third parties with connection to the parameters of the default judgment and the unnamed parties. So Namecheap, 2Cows, GoDaddy, Cloudflare, GitHub, Discord, Google, and Reddit. This is not signed yet, and we don't have an entry in the docket granting it yet, so it's not entirely clear that they're going to get 100% of what they ask for. But it would be normal. It would be normal for this court in this situation to grant the limited discovery and allow Nintendo to find out more about the claims, whatever it can discover from those sources about the defendant. But also, I'm assuming you're going to ask a bunch of questions about the people, the usernames, IP addresses that they think are associated with the associates or co-conspirators of a defendant. And then, yeah, Nintendo will probably name the worst of those co-conspirators. So far, I haven't seen Nintendo name individual consumer pirates as defendants in these things. Not that I support the individual consumer piracy of Nintendo games. We can talk about the philosophy of copyright and piracy and whether it's stealing or whether it's a different kind of stealing called infringement that's not called stealing because it's not the same thing, or whether they're deprived of a sale, whether every piracy infringement deprives Nintendo of a sale, or whether a number of infringements actually would never lead to a sale and might actually lead to more sales because of the greater use. But then, of course, if all they did was have infringement, then they wouldn't make any money either. So how do you balance the incentivizing of making new intellectual property, like yours truly is trying to get into making new intellectual property? What if I couldn't monetize my work? Would I still want to do it? If I want to put something out into the world and I want to be able to rely on it to provide an income for me in the future, if I put out something quality that people want to buy, what is the problem with me then in trying to enforce my rights and try to keep people from getting it for free? And then there's the argument that, well, what if I offer my video game, for example, for too much money? You know, it's $1,000 a copy. Nobody can play it because nobody wants to buy a $1,000 video game. Well, don't I have the right to do that? But then what's the argument that because I've been immoral in offering this to the world for such a high price, you know, that piracy is okay? I don't personally believe that piracy is okay in that situation just because something is a high price. How about the argument that piracy is okay when you do want to pay for something and you can afford it, but they won't let you because you are region locked or because it's not on your service that's available. You have to... I'll tell my story that I've told before, that Mythbusters, you know, Jamie Hyneman, Adam Savage, Discovery Channel Mythbusters was not available on streaming services for a long time. They were probably locked into cable TV agreements. So if I wanted to watch Mythbusters, you know, more or less when it was available, I had to have a cable TV or DirecTV subscription, had to have the Plus package because Discovery was never part of the base package. And then, and only then, could I watch Mythbusters, having to pay $100 and some $20 a month. So maybe any potential or any unadmitted to piracy that occurred before led to more sales later because it was never about the piracy, it was about the access. Anyway, these are legitimate arguments to have. They can be had all day on Reddit. But when you start to say, give me this money and I'll give you this game illegally, or I'll give you this information, or I'll give you this tool about how to obtain the game illegally or how to unlock your game illegally. And then, of course, there is still a level of that is legal where you are allowed to archive your own games. You're just not allowed to go get new games from the internet in an unauthorized way. So it gets complicated. And if you do the illegal part on, say, Reddit, for example, yes, these things are discoverable in legal process. This was always true. This may be new information to you or to some people, but it is not new information to corporations, to the law, to law enforcement, to lawyers, anything. You could write a letter to your grandma, and under the appropriate circumstances, that letter could be discoverable in a court of law. That's the way things are. That's why people have phone calls, or when they think that their phone calls are being monitored, they meet in person. And when they think their meeting in person is being monitored, they sweep for bugs, or they try to meet in a, et cetera, et cetera. That's why people do these things. That's why we didn't, until the age of the internet, communicate via text message, because you're making records of absolutely everything that you do at all times. So, yeah, that's what's going on with the Nintendo versus Reddit. It's not just Nintendo versus Reddit, it's just that's the most dramatic part of the story. They're trying to get identifying information and default judgment-related records about sales. How extensive was this thing? Was it 5 people running it and they sold to a couple thousand customers? Or was it 100 people running it and they sold to a couple million customers? What happened? And then if they can identify additional co-defendants or co-conspirators, it looks like they're prepared to name them in an amended complaint. If you were a customer of this, yeah, you you'd want to pay attention to this, and you maybe should be a little worried. If you were a participant in the higher level operations, you're probably the target of this. And you'd want to contact an attorney if you haven't already. You can contact me, just search for my name, and you'll find my contact information. You can write me, call me, text me. But yeah, if you were worried about your public posts on Reddit being able to be used against you, yes, that can happen, and that's why you generally don't commit crimes via records, especially publicly available records. Also, just don't commit crimes. If you don't commit crimes, then you don't have to worry about it. But, you know, if you had to commit a crime, you don't want to have a record of it. It's just one of those dumb things. It's like the Marcus Brownlee thing, posting him speeding through the residential zone with the blurring out the main dashboard, but forgetting that there was like this cool feature mini dashboard telling everybody the actual speed off to the side that you forgot about. That wasn't as bad. It's just a speeding ticket and no one got hurt. So hopefully, you know, react definitely, but, you know, chill. But anyway, yeah, that's Nintendo versus, well, it's versus Williams, but it will now be versus Williams at all if Nintendo gets its way. Let me know what you think in the comments below.